There are four facets of the guarantee purchase process. The first one is the SBA is going to look and see how the loan was originated. Was it an approved loan? Was the borrower eligible, and was it an eligible business transaction? And the SBA is going to look to ensure that the loan was originated in accordance with the federal regulations and also with the SBA SOP, or Standard Operating Procedures, which were in effect at the time the loan closed. And particularly where you are dealing with a situation where it is a questionable area and you are modifying the loan, the SBA has delegated a significant number of decision-making issues to you as the lender. And those delegations are set forth in a servicing liquidation action matrix. And because the matrix does change from time to time, it's very important if you're making a decision, particularly if you're a PLP lender, that you make a copy of the matrix that you are relying on at the time you make your decision and staple it to your memorandum that you put in the file. Next, the SBA is going to be looking to see whether you closed the loan in accordance with the authorization. Did you get all of the things that we've been talking about for the past 50 minutes? And if you haven't gotten them, has the SBA suffered any loss because of your failure to satisfy these requirements? In addition, the SBA is going to follow through and make sure that the loan was actually serviced in accordance with the loan documents and the SOP, and that you acted as a prudent lender in servicing the loan. You can't just look the other way because you have the SBA guarantee in place. Because if the SBA suffers a loss because of your failure to service the loan properly, they're going to either require repair, which is basically a reduction in what they're going to guarantee, or they may possibly completely disallow the guarantee in its entirety. And lastly, what the SBA is going to be doing is they're going to be looking to see whether you liquidated the collateral in accordance with the SOP and followed prudent lender practices. And frequently, lenders who go out to realize on collateral, we were just working with a lender that was dealing with a small manufacturing company. And in some instances, you're dealing with equipment that has very limited market value. And you're dealing with a landlord who's giving you a very short rope to get that equipment out of there. You better have that signed landlord waiver in your file, which allows you to get the collateral back. But where I'm getting to with this is the SBA does not require you to act unreasonably with respect to collateral recovery, but you have to act as a prudent lender, which means value the collateral and take prudent steps to value it. And if you have any questions, talk with your district office because they are available to provide you with advice as to how to proceed. Now, there are a couple of options as to what may happen after the SBA evaluates your repurchase request. One, if you submit a complete package, and if you've done a good job from the time you originated, closed, and serviced the loan, and as appropriate, liquidating the collateral, the SBA, my understanding is, honoring the 45-day brand promise, and in fact, they're processing completed packages, as we started out earlier today, saying that they're processing these packages within 25 to 30 days. If you have made a mistake in your underwriting, closing, or servicing practices, and there is a material deficiency whereby the SBA suffers a loss so long as it's not the full loan amount, the SBA may require repair, which means they will not honor the full guarantee. And for example, one example that's frequently used, is the borrower is required to get life insurance, and you neglected to get life insurance until and you didn't neglected to require the life insurance and the collateral assignment of policy at the time the loan closed. And lo and behold, the borrower goes into default, and there's no life insurance on the guarantor. The guarantor is not dead. The SBA has not suffered a loss, so they're not going to require repair there. If, however, the loan was for a pizza restaurant, and Joey, who was the sole proprietor of the pizza restaurant, drops dead during the first month the business is open because he's about 400 pounds overweight, the SBA is not going to honor the guarantee, and they're either going to require a repair or a complete denial. And the SBA can deny the guarantee in full. As I noted before, there is headquarters concurrence whenever there's a denial.